What if a buyer who purchases a property subject to existing loans dies after the close of escrow, which means that the buyer actually owns it? There's title in the name of the buyer. And to answer that question, we have to know whether how the buyer took title. So for example, if the buyer took title in the name of an LLC, well, in that case, the LLC doesn't die. The LLC doesn't go away. The buyer is a member of the LLC. So let's say that the LLC's member dies. In that case, nothing changes. We identify an individual as being the buyer when in reality they took title. They were an investor. They took title in the LLC. Well, the LLC continues to own the property. The LLC will have to continue to make the payments. So whoever's responsible for the deceased member's estate will have to step in and make sure that the payments are being made on the existing loan, and the property is being kept up and everything's being done properly with respect to the property. But nothing changes. The LLC doesn't go away. It survives the death of its member, and the original seller, it doesn't change anything with the original seller. The original seller doesn't receive any additional rights with respect to the property. The existing lender doesn't receive any additional rights. It's simply a death of a member of an LLC, but the LLC continues to own it and continues to be able to act as the owner of the property as long as they fulfill their requirements to the seller under the original agreement. The next scenario is that you have an end buyer. So you have a buyer that ends up buying it in their personal name subject to the existing loans. So this would likely be a situation where the seller sells it to an investor subject to existing loans, and then the investor sells it to the end buyer subject to the existing loans and has some carryback financing as to that buyer. Well, let's say that that individual buyer passes away. Once again, the original seller, the investor who sold it to the buyer, doesn't receive any additional rights as long as that buyer's estate basically continues to perform under the original agreement with that investor, meaning they're paying the existing loans. They're paying the portion of the loan that's owed to the investor. They're basically performing under their agreement with the investor that sold it to them. None of that changes. Instead, the property becomes an asset of the deceased buyer's estate, and the deceased buyer's personal representative, or some states call it an executor, will be responsible for handling the affairs of the property, making sure payments are properly made under the loan with the investor seller. And then at some point, the estate will be administered, and the interest held by the buyer or deceased buyer will be conveyed to that buyer's heirs. And that buyer's heirs will then own the property, and they too must continue to satisfy the loans against the property and making sure that they're making the required loan payments. Another option is the deceased buyer's personal representative can decide, well, we don't want to keep the loans in place, and it makes more sense to sell the property. And so maybe they go and they sell the property to a third party, in which event all of the existing loans, the investors carryback financing will be paid off. It basically everything's paid off, and then the property sold to a third party. So that is what happens if a buyer passes away after the close of escrow on a subject to transaction.